If their opinions don't align precisely with our nonpartisan stance, we're going to live with that because we honor freedom of speech that's guaranteed by the Constitution, so far as I know. I guess as of last night. Now, on your seat, you have index cards. You are welcome to jot down questions at any time that occur to you, but we are holding all the questions till the end. So here's the process. When you have one that you would like one of our hospitality members to pick up, you can do that in between speakers or at any time. Just hold it in the air or pass it to somebody at the end of an aisle, whatever suits you. We have a highly trained group at the back who are a question and answer team, and they will look at the questions that get submitted and see if there are any duplicates or if some are more clarifying than another. And for the last 30 minutes, so from 7:30 to 8 o'clock, they will bring up the questions to me and I will pose the questions to our speakers. So it's not like some programs where after one person is done speaking, then you can ask questions. We're holding all the questions so that everybody gets a chance to tell their whole story. Now, the other way we do that is we have two beautiful timekeepers here in the front. Two very uncommitted on that. Sue Malley and Cassie Percival. And they know approximately how long each speaker has identified that they're going to speak, and if time gets short, they're going to hold up time cards. If that doesn't work, I'll go over and tap them on the shoulder and say, time to go. Also, another thing is the survey. So you are welcome to fill that out at any time that is convenient for you. Okay. And finally, please remember that audience photos and videos are not permitted. That's generally how league programs operate, but in this day of artificial intelligence and so on, we trust you, but you never know what somebody would do if they got a snippet of a video or a photo and make it unrecognizable. So we have a very handsome videographer over here, Scott Courtney, whose wife is a member. Scott was a member for a year, so we were very happy about that. And then various members are taking pictures. You may have noticed that we have a park ranger in the facility here, so he's our security. He's kind of bedecked. I mean, he has telescopes and all that stuff. It's a different kind of security than we usually have for our meetings. But I'm sure he's tough. Okay, so let's go ahead and I will formally, I guess I have already formally introduced our speakers, and we will begin with something very special. Joe, take it away.
Thank you. You all know that the battle for this country's heart and soul began in Massachusetts as a revolution 250 years ago this past spring. This coming July will mark the 250th anniversary of the Declaration of Independence, which of course led to a new nation, a new way of governing called the Articles of Confederation, which will be covered by Professor Dreussi, followed by a new Constitution, Bill of Rights, with separations of powers to be covered by our anchor, retired Akron Law School Professor Dean Carro, followed by interpretations of said Constitution by the United States Supreme Court and others, which I'll try to briefly cover. Obviously, constitutional law is a year-long course in law school, with several hours of classroom time, several hours of reading and preparation. We can't do that in less than 90 minutes. So we're going to try our best to offer you the historic underpinnings and sort of a primer on how we got to the Constitution and where it seems to be now. With that, we're going to go back in time to the Declaration of Independence, which we shall dramatically read shortly. as it was done in the old days. Hear ye, hear ye, hear ye.
In Congress, July 4th, 1776, the unanimous declaration of the 13 United States of America. When, in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare causes which impel them to this separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among those are life, liberty, and the pursuit of happiness.
That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of those ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed.
But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new gods for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world.
He has refused his assent to laws, the most wholesome and necessary for the public good.
He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only.
He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people.
He has endeavored to prevent the population of these states, for that purpose obstructing the laws of naturalization of foreigners, refusing to pass others to encourage their right migrations hither.
He has made judges dependent on his will alone for the tenure of their offices.
He has erected a multitude of new offices and sent them hither swarms of officers to harass our people and eat out their substance.
He has kept among us, in times of peace, standing armies without the consent of our legislators.
He has affected to render the military independent of and superior to the civil power.
For quartering large bodies of armed troops among us.
For cutting off our trade with all parts of the world.
For imposing taxes on us without our consent.
For depriving us, in many cases, of the benefits of trial by jury.
For transporting us beyond seas to be tried for pretended offenses.
For taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments.
He has excited domestic insurrections among us.
In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince, whose character is thus marked by every act which may define a tyrant, is unfit to be the ruler of free people.
We therefore, the representatives of the United States of America in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by authority of the good people of these colonies, solemnly publish and declare
that these united colonies are, and of a right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved.
And that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all acts and things which independent states may of right do.
And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor.
Our thanks to Beverly Proctor Donald. She is the current president of the Stark County Bar Association, consisting of several hundred lawyers in Stark County. She's a family magistrate in family court. And our thanks to a longtime officer and director, Dr. Carol Canavan, who was recruited to do this, and we think did very well. Thank you all. Thank you, Diane.
Okay, so, as we heard, there were a lot of complaints about what was happening in this country. I think it's safe to say that the British Crown treated the colonists shabbily at best. You know, one of the big concerns was the taxes that were imposed. I mean, nobody likes to pay taxes, but people like to pay taxes even less if they have no ability to have a say in how those taxes are levied and the duration of those taxes. And so, we all know.
Can you get closer to the microphone?
I guess you can do that. Is this better? Oh, loud voice. If you can't hear, just raise your hand and I will holler. Okay. So, we all know the Boston Tea Party was about exactly that representation lacking while taxes were being imposed. Thank you, Dean. You know, the Crown didn't take well to that. So when they did that, they passed what were known as the Intolerable Acts. And these acts did things, as some of which we heard in the Declaration of Independence. They took the charter away from the Massachusetts Bay Colony. They closed the harbor in Boston. They imposed a series of really onerous burdens on the colonists that just infuriated them. And it was meant to be punishment, but it served to galvanize. It served to inflame people, to bring them together. And so we saw in a year later, 1774, in October, the First Continental Congress. So for the first time, representatives of the different colonies got together and expressed their grievances and expressed what they were angry about. It was a real show of unity, the likes of which we haven't seen in the past. Although they've already, at every stage, it's important to note that at all stages they were hedging their bets. You know, they were very polite in their addressing of the king, but meanwhile, they were starting to form militias. They were getting ready, just in case. They addressed the king in the most polite manner possible. In fact, the missive that they sent off to him after the Congress was over began with, "We, His Majesty's most dutiful and loyal subjects." I mean, we just wanted to start a dialogue. We wanted to have a conversation. We wanted to explain why we were ticked off. Well, you know, they also listed a lot of those other things that we heard, because the grievances that were expressed to the king in the Continental Congress were recycled again in the Declaration of Independence. The privileges and immunities of citizenship, life, liberty, and pursuit of happiness, and the ability of the government of the colonists rather, to petition the government for a redress of grievances. The other way they were hedging their bets was they said, you know what, this doesn't work out, let's do this again next year. So King George, despite that polite demeanor, was not amused. He was infuriated. The temerity of these lousy colonials to question what he was doing, what he was saying, no, that wouldn't stand. And so he said, that's it, we're So that Second Continental Congress got together, and 7 months after the first, 1 month after the war had actually begun, after blood had been shed at the battles of Lexington and Concord, and they issued the Declaration of Independence. So here we are, we're done. We're done with Britain. So they had to set up a form of government, and that form of government was expressed in the Articles of Confederation. And so when you think about it, they were angry about the agglomeration of power all in one man, in the king. So what they wanted to do was the opposite. They wanted to spread the power around. They wanted to have a decentralized government.
We've been canceled.
Now we know how Jimmy Kimmel felt. And so they put together what seemed like a really good idea at the time, a confederal form of government where all the power was at the state level. There was no central authority, no president, no central taxing authority, no ability to control tariffs, or there wasn't even a common currency. There was no judiciary, but they thought it was going to work. It didn't. It was, we won the war, thank goodness. You heard those stories in grade school about Valley Forge and all that stuff. Well, the big problem there was that we didn't have any money. Taxes were voluntary. There were no federal taxes. And states weren't all that excited about paying up. So we had this massive debt we were accruing, and we didn't have any ability to pay it. We were losing what little shreds of credibility we had internationally, and we had trade between the states that was a nightmare. Different states had different currencies. Goods that were manufactured in Pennsylvania and sold in Virginia were subject to tariffs. It was an absolute nightmare. And so we realized something needed to be done. And George Washington said, that confederation was little more than an empty sound and Congress a nugatory body. So, 1787, the Philadelphia Convention that we know now as the Constitutional Convention convened to amend the Articles of Confederation. So Dean's going to take it from there.
Thank you. 2 questions. Are there any lawyers in the group? You'll forgive me. Where are the young people? You're shaking your head. Where are the young people? Seriously, does that disturb anybody?
Yes.
It should disturb you greatly. It should disturb you greatly because that is a generation that is largely uninvolved. And the key to the United States Constitution begins with the first 3 words of the preamble. We the people. We the people.
Dean, is your mic on?
I think it is.
Does
Is
it
it
sound
not-
like it's on?
Can you hear me? Thought I turned it on. Can you hear me okay? I didn't do anything. Okay, so you have a copy of the Constitution at your seats, all right? We're going to go over them. We're going to have somebody read a little bit to us. So the first thing is why did that get messed up? The Articles of Confederation. Anybody remember Shays' Rebellion? You remember Shays' Rebellion? What was it about?
Whiskey Rebellion?
That was the Whiskey Rebellion. That was Pennsylvania. Shays Rebellion was in Massachusetts. These guys come back from fighting the Revolutionary War, and a lot of them didn't get paid. Massachusetts passed some laws that indebted them for taxes and foreclosed on their property. And so how do you think Americans reacted to that? Not well. We had just liberated ourselves from oppression. No taxation without representation. Very good. So the whole idea was they didn't like it, and what did they do? They rebelled. The problem created by the Articles of Confederation is there was no central, no federal power. So who took care of repressing, the rebellion? The militia, the Massachusetts militia. Somebody mentioned the Whiskey Rebellion. That was later. That was in Pennsylvania. What they started to do there was tax whiskey. Now, what did farmers do with their excess grain? They made whiskey. And a guy named George Washington also did the same thing. Who was the only president, while president, to lead federal forces into combat? I'm sorry? I don't know. I'm asking you. George Washington. So, think about this. George Washington comes out and leads the troops and quells the rebellion. Why is that important? When we think about the Constitution, we're starting with page 1, okay? Look at your document. This is going to be interactive. Page 1. Page 1 of your Constitution. And I'll expect you to read it, and we're going to have an exam at the end of it. Page 1. Page 1. What's it say? It's the preamble. What's a preamble? A preamble is an introduction outlining what is to follow. What are the first 3 words? We the people. So this is novel. This is unbelievable. Prior to this, where did power come from? The king. Right? Very good. So the king gave power, gave maybe something to the people if he wanted to, or the queen, or the empress, or the emperor, or the czar. So this is unbelievable. Now, why is this remarkable? Who were the framers of the Constitution? Primarily, mainly, lawyers. But there were 2 exceptions to that. What were the 2 exceptions to the lawyers? Benjamin Franklin and George Washington. Now, can you imagine what kind of human being George Washington was? All these important people, Jefferson, Madison, Monroe, all looked to him as the person who was going to be the first president of the United States. Can you imagine what kind of man that was? Now, he was a big guy. He was tall. He was also a slave owner. He had a big plantation. But he must have been a remarkable individual. Why do I mention the fact that most of them were lawyers? What are lawyers used to dealing with? There's a lawyer in the group here, right? What are lawyers used to dealing with? Problems. Problems, okay. Problems, ideas, language, principles, theories. These people who framed the Constitution were great students of history. They knew Roman history, they knew Greek history, they knew European history, and they understood some basic things. Number 1, they understood that what did power do to people? Corrupt them. It corrupted them. What does absolute power do to people? Corrupt them absolutely. Have you been through this class? So absolute power corrupts absolutely. So their whole idea in the Constitution was to divide power. But the premise was power came from the people. Okay? So we, the people of the United States, we have separate branches of government. And the shorthand acronym is LEJ, L-E-J. L stands for legislative, E stands for executive, J stands for judicial. Where did we find these people?
We had civics when we were young.
Did you? That doesn't happen much anymore. I don't know if you're aware of that. So, the first article, legislative, second, executive, third, judicial. Why did we do that? We did that to separate powers, really the focus of my conversation today. So the whole idea is to look at the enumerated powers. Look at page 6, Article 1. Page 6, Article 1. Article 1 is a legislative branch. They thought that that was an important branch. Why? Because they never had much representation. They wanted the people to have representation. Article 1, page 6, what's that deal with?
Page 1.
Huh?
Oh, okay, I'm sorry.
It looks like this. It's a circle
Yes,
of 1.
yes,
Page 6, isn't it?
yes.
But the article starts on one.
Yeah, mine is the same one you have. Page 6, enumerated powers.
It doesn't say that.
Yeah.
Yeah.
That's what we're talking about. So, what they do is they enumerate powers. What does that mean? The power to borrow money, to regulate commerce. What does that mean? What does it mean to have enumerated powers? They list them. Why? Why did they want to list them?
So now we have to
So no one has
and reason to doubt what they
to
have.
doubt what power they have. So it's expressed. It's right there. So there's no question about that. So the enumerated powers, that's a great example. Look at Article 2, page 9. By the way, do you notice the shape of that? Kind of rounded. Article 2, page 9. What does that deal with? Executive powers. Who's the executive? The President of the United States. So here's an interesting thing. They have a legislative body that's divided into how many houses?
Two.
What are the two houses? The House of Representatives and the Senate, right? Which one is more powerful? Neither. Depends how you look at it. Depends how you look at it. What's the term of office for the House?
2
years. What's the term of office for the Senate? Why? They wanted to have them hanging around. They wanted a senior house. They wanted a continuing group of people, right?
Knew what happened before.
So they knew what would happen before. So again, this points to the cleverness of the people who drafted this thing. It's unbelievable because it didn't exist. None of this existed before then. Okay, now I want to get to an example. Article 1, Section 9. Okay? Article 1, Section 9. What's that deal with? Clause 2. Page 8? Page 8? Mine was 8.
Migration or
No?
deportation.
I'll tell you what it is. I think we have the same copy because I took it from the group. Okay. Article 1, Section 9, Clause 2.
Clause 2.
Habeas corpus. All right, what is habeas corpus? Who said that?
Bring forth the body.
Who said habeas corpus? What is it?
Bring forth
Brings? Huh?
The right to like a fair trial.
No. Bring habeas corpus, present the body. Very good. So habeas corpus is a right under the Constitution. And in this section, who does it appear has the power to suspend habeas corpus? What article is it in? First article. Very, very good, very good. So the point I'm making here is you got a guy who's elected in 1860. And who is that guy? Abraham Lincoln. What happens in 1861?
Civil War.
A civil war. Oh my God. And what's happening contiguous with that is you're having riots, you're having fights, there was rebellion in cities. So Abraham Lincoln, who has now grown a beard, because the kid wrote to him and said, "You're really ugly, and you should have a beard." That's not why I have mine. Lincoln is forced to wear a shawl to get into Washington, D.C., protected by patriotism. At the same time, there are fights all across the United States at the time. So what does he do? He suspends the writ of habeas corpus. So the question becomes, where does that power lie to suspend the writ? What would you say, based on what you just read? Only Congress, right? So here's the interesting thing that happens. During the Civil War, as he suspends it, in 1813, Congress adopts a bill and he signs it that forgives him for his mistake. It forgives him for his mistake. Here's an example of the separation of powers and the operation of the separation of powers, how it works. He exceeded the United States Constitution by suspending the writ of habeas corpus. Number one. Number two, there's a third branch, Article 3. What did the third branch do? The third branch, in a case called Ex parte Merriman, decided that he had exceeded his authority. And Chief Justice Taney, who was a very interesting person in his own right, Chief Justice Taney, why are you smiling? You know why he's an interesting person? He was a slaveholder. So Chief Justice Taney issues the writ of habeas corpus. So here's an example of what could happen when the system works properly. Congress passes a bill saying, you exceeded your authority, President, but we're going to forgive you. The United States Supreme Court says you exceeded your authority, we're going to issue the writ of habeas corpus. So it did that in the Merriman case. Why is that so interesting? It's so interesting because you're in the midst of a civil war, and it's still operating. Remarkable situation. Okay, now I want you to look at Article 2, page 11, Section 2, Clause 2. Article 2, page 11. Article 2, page 11. You got it?
Yeah.
What's that? Article 2 is? So, Commander-in-Chief, the executive, the president. And what does this allow for? Take a look at it. What's it allow for?
Chief of the Army.
And what else? And what else? And what can he do under Clause 12? Section 2, Clause 12.
Call for the militia.
Okay, so now what he can also do is he appoints officials in the federal branch. But how does he do that? Does he just come down and say, you're my Chief Justice? Where does he have to go with that? To the Senate, right? Have we seen it in our life? Many times, right? Any cabinet officer, any judicial officer of the Supreme Court has to be approved by the Senate. So how does it work? The president nominates, the Senate affirms. Very good. That's how you get to be there. Now, does the president have the authority, to dismiss a member of the federal branch? Yes. But he doesn't get to be a member of the federal branch until the Senate says so. It's very important, okay? Any questions about that? Okay, let's take a look at Article 3, page 12. Article 3, page 12. What's that deal? And what's the highest court in the United States? Supreme Court. Where does it sit? Why does it sit in Washington, D.C.? That's the capital of our country. And that's also discussed in the Constitution, right? At the time, it was a swamp. And there was no real center for the United States Supreme Court. Anybody ever been to the U.S. Supreme Court?
Yes.
Fantastic, right?
Yes.
Fantastic thing. It really inspires you that we have faith, we have hope. And in my view, the hope comes maybe at this time in the federal courts, the circuit courts, the district courts, and to some extent, I'm sorry?
I said the federal courts, not the Supreme.
I didn't say the
I know
Supreme,
you
did I?
didn't.
I said I have a lot of faith in the district courts and the circuit courts. The U.S. Supreme Court, that's another issue. We don't talk about that. So, we have the basic structure of government. Where are the rights? Where are our rights? Where are the individual, where? In the what? In the Bill of Rights. This is the original copy. I wasn't there. But this is the original copy of the Bill of Rights, okay? So what is the first bill? Go down here.
Freedom of expression.
Article first.
Freedom of expression.
After the first enumeration required by the first article of the Constitution, there shall be one representative for every 30,000 until the number shall amount to 100. After which the proportion shall be regulated by a word I can't read, that there shall be not less than 100 representatives nor less than 100 representatives for every 40,000 then one representative, for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportions were regulated by Congress, that there shall be not less than 200 representatives, nor more than one representative for every 50,000.
Now, we paid this woman a lot of money to read this.
Really?
But is she right? Look at page 21. Page 21, I think it's page 21. What's the First Amendment there? Wait a minute, that's not what she just read. Did you read the wrong thing?
I did, you pointed to it. How could
I get blamed. So, the one that she read didn't make it. The second one didn't make it. The third one, look at the third one. Look at the third one in this. I paid you $100 to do this. Every three.
Congress shall make no law respecting an
Stop.
establishment.
Does that sound like what you got in front of you?
Yeah.
Right. What happened to the first two? There were originally 12. A guy named Madison drafted 12 of them. First two didn't make it. One of them made it as a 27th Amendment sometimes later. But those two didn't make it. They didn't need the 30,000 because the population had gone up, so that's irrelevant. But they also had a provision that the Congress that raises their salary shouldn't benefit from it. We see that in the 27th Amendment. So the point that we're seeing is, is we don't have exactly what Madison wanted, but what you've got is remarkable. Let's take a brief look at those amendments. First Amendment, freedom of speech, freedom of religion, freedom of... Anybody read the Canton Repository?
Yeah.
You do? You actually read? Okay. Canton Repository, freedom of the press, right? So you can't have government religion, and everybody can practice their own religion, and you have freedom of speech, and you have freedom of the press. Second Amendment, what's that deal with? Right to bear arms. Why? Where did the militia come from? Who was in the militia during the war? Farmers. Farmers. Where did they have their muskets? Above the fireplace. So, Joe, ring your bell. Joe's there. Joe rings the bell. You grab your musket. Where do you go? You assemble, right? The town square. And if you don't have the right to possess a weapon, you don't have a militia. Second Amendment, key amendment, very important today. Third Amendment, what's that deal with? What's the third deal with? You can't quarter a soldier. Where did we hear that before? In the Declaration of Independence. Much of what you hear in the Declaration surfaces later in the Bill of Rights. Fourth Amendment. Unreasonable searches and seizures. Very, very important. Very important. So I'm a cop. Stand up, sir. Yeah. Sorry, man. You know, so I'm a police officer. You're knocking on this door. You're turning the doorknob. It's 2 o'clock in the morning, and you're downtown Canton. Ooh. What am I thinking? I'm a cop. What am I thinking? You're gonna rob. Okay. So what does the Fourth Amendment allow me to do? I've not charged him with a crime. He's not been found guilty of a crime. Under a case called Terry versus Ohio, I can pat him down because I'm suspicious of him engaging in criminal activity. Why am I patting him down? To see if he's armed and dangerous. I won't pat you down because that would involve touching your groin. You can sit down. So I wouldn't do that. Fourth Amendment, Fifth Amendment. Fifth Amendment, what's that deal with? Grand jury. Due process. What the heck is due process? Why did they use vague terms? Because they knew that this country was going to last, or at least they hoped it would. They knew it was going to last, so they had vague terms that could be reinterpreted depending upon the time. Sixth Amendment. What does that deal with? Speedy trial, the right to counsel. Joe Martuccio was a public defender. Scary, isn't it? He was a public defender, and he represented poor people who could not afford to hire counsel. There was a guy who was just tried for an assassination attempt on a candidate named Trump. And what did he do, in my opinion, very stupidly? Representing himself. We have an old saying among lawyers. The person who represents himself has a fool for a client. Okay? So Sixth Amendment. Seventh Amendment is civil. Eighth Amendment, what's Eighth Amendment? Why is that important? What if you have no money? You're going to sit in jail. How many people want to sit in jail? How many people have been, don't answer that. I spent 10 years in jail every Friday night as a federal monitor. And it was a pain in the neck, because I had to eat a meal on each range. That's how I got the Peter side. And so the idea was I was supervising a federal court order. Nobody wants to be in jail. If you can post bond and get out, you're good. Ninth Amendment, I think it's the key amendment. This is a very lawyerly thing. Lawyers will often say, just because we didn't mention it doesn't mean you don't have it. That's what the Ninth Amendment says. The enumeration of certain rights doesn't mean you don't have other rights. Unfortunately, it's rarely been used for a variety of reasons. 10th Amendment, any power that we haven't designated for the legislature, for the executive, or the judicial rests with whom? Or the people. Goes back to that theme. Okay? I think I'm done, right?
Do you think so?
I only had 20 minutes, right?
We got 4 more minutes.
Oh, I don't really need it, but I can go.
You need time.
Any questions about the articles? Any questions about the Bill of Rights? Any questions about the article? No questions about the article? Go ahead.
Was it set up in the first body of the Constitution how we go around about making the amendments?
Yes, yes. So that's in the articles, and it basically says the way it works is Congress will propose an amendment, then it goes to the states, and very good, to ratify. Now that process takes a long time. For example, the Equal Rights Amendment never really made it until recently, maybe, we're not sure. But it does take it's a long process. Yes. Very good. Other questions? Okay, done.
All right. I think it's easy to see why Professor Carro and Professor Dreussi were loved and respected by their students. You didn't know you were going to get a workout tonight. Thank you so much. You are exemplary citizens. You've come because you want to understand. The League of Women Voters does a lot of educational work in the fall. Typically they preview and try to put on some experts to help identify an issue that's on a ballot. They're not allowed to take positions on individual candidates, but they can take positions on issues. So you are here for very important reasons. Not necessarily something that's coming up in November, but having an educated electorate makes for better choices when it comes time to elect people to the House and the Senate and the executive branch, right? Because they do a lot of things with our lives. And I'm going to work my way to the Supreme Court in talking about some of those things they do. Dean mentioned earlier that most of the framers of the Constitution were lawyers. Lawyers don't have a lock on all the best and brightest ideas or the best behavior, but people who've written about behavior and understand it have mentioned them for years. About 500 years ago, a guy named William Shakespeare in Henry VI wrote a play in which Dick the Butcher was out trying to just get everybody all razzled up, rouse the rabble to abolish government, to have anarchy. So what's the first thing he says as he's out there whipping the frenzy out of this crowd to get to anarchy? The first thing we do, let's kill the lawyers. Right? Because they stand between civilization and rule of law and anarchy. So, a couple of things, true or false. In the Constitution and the Bill of Rights, you will find the phrase separation of church and state. No. True or false? False. False. That concept was first brought to light by another learned philosopher named John Locke, who preceded Thomas Jefferson by decades and decades. Thomas Jefferson, in writing a letter to the Danbury Baptist Association, they were concerned that they might not have the right to exercise their religion freely, that they might be regulated. And he wrote them assurances saying, no, And he used the phrase, there is a wall of separation between the government and you. You will not be regulated. And that appears in his letter. Later, judge-made law, the courts embraced that, and it's going to morph into a few other things that I'm going to try to get through pretty quickly. True or false? The phrase, right to privacy, appears in the Constitution and or the Bill of Rights. False. The concepts are there, and they were amalgamated by the Supreme Court in 1965 in a case called Law. Connecticut had a law in the books that made it a crime to use birth control. One of the people who were arrested and convicted of a crime from Planned Parenthood, the director of Planned Parenthood and a doctor. They wanted to provide contraceptives to married couples for very obvious reasons involving health and so on and so on. But they were charged and convicted of a crime. The Supreme Court, in analyzing that in 1965, said, wait a minute. We're getting into the bedroom. This is a lot of government intrusion. And they used the phrase zone of privacy. It first appeared in Griswold, zone of privacy. And they cobbled it from several amendments among the Bill of Rights, what they call a penumbra, the shadow. You know, we could use bits and pieces of all these things. I wanted to mention the amendments. There were 27, actually 11 through 7 came after the first 10, some pretty close in time. 12 created the Electoral College, for better or for worse. 14 extended. 18, well, it's 13, you're going to boo, created income tax, federal income tax in 1913. 18 in 1919 prohibited liquor. That was a failed experiment, as I think we all know by now. It gave rise to a criminal syndicate underground of huge proportions. It was later repealed in 1933 by the 18th Amendment. It was the 20th Amendment, that 19th Amendment, that gave women the right to vote in 1920. So it's only been 125 years. The one I wanted to mention for just a second, because it dovetails into another Supreme Court case I'm going to talk about briefly, is the 26th Amendment. That was enacted in 1971. I was turning 18 in 1971, and it lowered the voting age to 18 years of age. I was one of the first people eligible to vote as an 18-year-old in federal elections. And I did. And I voted for the loser. I voted for McGovern. Even at 18, as crazy and immature as I wasn't sure I liked the current president who was running for re-election, Richard M. Nixon. There was something about him. And I'm going to get in one of those cases, too. A couple more thoughts about the framing of the Constitution, and then I'm going to talk about the structure of the Supreme Court and hit the highlights of several of their decisions. We talked about how some of these folks understood human nature, Shakespeare, Locke, and others. James Madison, the fourth president of the United States, who also led troops into combat, but after he was elected president, had said in its quote, "If men were angels, no government would be necessary." And in Federalist Paper number 10, James Madison wrote, quote, enlightened statesmen will not always be at the helm. Enlightened statesmen will not always be at the helm. So he was writing in Federalist Paper 10 an argument for separation of powers, checks and balances, co-equal, and so on. He wrote that among 29 essays. There were 85 essays in the Federalist Papers designed to encourage other groups like the New York representatives to adopt the Constitution. Of course, Hamilton wrote 51, and John Jay wrote 5. All right, to the Supreme Court. 3 is a big number. Not only is 3 separation of powers, legislative, judicial, executive, but it's also how many levels of court we have, both in the state and the nation. The first level is generally known as the trial courts. That's where most of the work is done. Trials, juries, motions, that kind of thing. The second level above it is called the Court of Appeals, the appeals courts. If someone alleges that the district courts were wrong, the appeals courts can try to help decide that. And above those, in every state but New York, and in the United States, the highest court in the land is called the Supreme Court. There are 94 federal districts courts in the United States, 94, 2 in Ohio, northern and southern. There are 12 circuit courts of appeal. So if you don't like how you were treated in a federal court in Ohio, you go to Cincinnati, where it's headquartered, and they hear cases from Michigan, Ohio, Kentucky, and Tennessee. There are also bankruptcy. There's a federal bankruptcy court, a court of taxation, a court of claims, and internal trade. The Supreme Court takes cases of great importance, of significant issues, of national importance, on what they call writs of certiorari, C-E-R-T, certs. There's something else known as a shadow or emergency docket, where they take some cases on for procedural reasons largely. That's come under a lot of scrutiny lately. So I wanted to share with you that the Supreme Court began with 6, went from 5 to 10 at different times in history, and since 1869 we've had 9 Supreme Court justices under Article 6, which is in your booklet. They have to swear 2 oaths. Now you know the process for becoming a federal judge at any level is getting nominated by the president, who has obviously designees do that at district courts and courts of appeals, and pay special attention to it for the Supreme Court. They have to be vetted. If they're federal or court of appeals judges, the senators in their home states get to have a say. But ultimately, it's a committee of the Senate, and finally the Senate, that approves or disapproves of a president's selection for the Supreme Court. Most of us in this room, I'd say, are old enough to have watched many of those hearings, and you know what a lot of those folks have gone through on both sides at different points in history. And you've seen and you've been the assessors of their credibility as to how you think they've managed the promises they made once they hit office. The oath, they have 2 oaths, but I'm going to read the combined one very quickly. I want you to know what they swear to, these Supreme Court justices. I do solemnly swear that I will administer justice without respect to persons and do equal right to poor and to rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me under the Constitution and laws of the United States, and that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office upon which I am about to enter. So help me God. Support and defend the Constitution, not a person, not an office, the Constitution. So, I was lucky enough to get sworn in at the Supreme Court to practice. Never did practice. I know Professor Carro here at sat second chair once. And it was on June 21st, 1989. Some of my law school classmates from Gonzaga and I went to and got sworn in. It's very surreal. Some of you have been there. You walk in, it's majestic, it's dark wood, it's burgundy drapes, and Rehnquist is staring at us with his stripes, and Scalia's scowling, and Thurgood Marshall's there. And anyway, we got sworn in, and I swore an oath very similar to that one. The reason I remember that day is because that day, June 21st, 1989, as we were leaving and celebrating, we were handed literally hot copies off the press of the Supreme Court landmark decision that was issued that day, and it was called Texas versus Johnson, a 5-4 decision in favor of the First Amendment. In 1984, Greg Lee Johnson burned a flag at the Republican National Convention in Dallas. Officials in Texas promptly arrested him and convicted him eventually of breaking a Texas law that prohibited desecration of the flag. He was sentenced to 1 year in prison and fined $2,000. The conviction was affirmed, but later it was reversed, but it made it way to the Supreme Court. And there, I want to mention a couple things. Judge Scalia, one of the most conservative people there, voted with the majority to say that and Kennedy wrote the majority opinion, as distasteful as it is, as much as we don't like the result, sometimes we have to do what's right. And that's what the majority said they were doing when they ruled that burning a flag was constitutionally protected conduct because conduct is speech and it was symbolic, and protected speech is one of the most protected of all. I'm going to say this because time's up, but and maybe these will come up. I have some cases that might come up in our questions and answers of the panel. Please, you've already shown how dedicated you are to understanding things like this. There are a lot of websites you can go to, just on an easy Google, to look at district court cases, Court of Appeals cases, Supreme Court cases. Some are absolutely neutral. The Supreme Court itself has a website that summarizes cases for you. You could read them and make up your own mind about how you felt that decision was rendered. And then there are many other websites that look at it from different points of view of different people on the spectrum: conservatives, liberals, presidential historians. So yeah, those cases may absolutely come up. And again, the one thing I wanted to emphasize was it's important for you to understand this and follow it, because you can help shape the future, not only of the presidencies and the Senate, but the Supreme Court. Those are lifetime appointments. Some of those people are there a long time. So thank you so much for your attention, and perhaps your questions will generate some of these as well. Thank you.
Okay, while I wait for the questions to come up, let me ask you one that's a burr under my saddle, and that is, if Congress authorizes funding for some reason, can the president say, nope, not going to spend it? Is that constitutional?
No. Once Congress allocates funds, the president is obligated to expend those funds in that way. And we presently have cases in the federal district courts and the circuit courts contesting the administration's desire to ignore them.
So those, it has to come up through the courts?
Yes.
Rather than...
So
Congress is not going to take any action.
So in other words, you have to wait.
Yes. If you look back to Lincoln's time, Congress took some action, right? It passed a bill, and Lincoln signed it, that said that when Lincoln had suspended the writ of habeas corpus, he was doing the right thing. This Congress will not do that.
It's like, I know the founders didn't think they would ever need this, but to me, it's like so much of it is like things are obviously unconstitutional, some of them because it's saying it in the actual language of the Constitution, and yet he can get so far that nobody stops him for months, for even more than a year. I know they didn't plan that, but it's like...
The framers didn't
No.
anticipate...
Microphone on, Dean?
I think it's on. Yeah. The framers didn't anticipate parties.
That's how I
Number
know,
one.
yes.
But number two, you've got to have faith in Article 3 judges. As Joe mentioned, you've got 2 levels before the Supreme Court. Those are doing their job. Now, it does take time, and you have to have an organization willing to bring a lawsuit, for example, the ACLU. And that is going to take its time to win its way through the court.
He's dismantling all of the
He can do whatever he wants to do.
Okay, so I appreciate the fact that you're raising a question. That's not how. Okay. The Constitution actually allows 2025 to centralize power in the branch.
We talked
Thing is that when they run for office, they go to the convention, and the convention has a platform for the candidate. So it's not unusual for the president to have a platform that says A, B, C, D. What the unusual thing here is, this was not created by anybody at the convention. This was created by an external group. Now, it's going to be tested just like everything else. Does it comport with the Constitution?
Yeah, the second part of that question was, is it constitutional to centralize power in the executive branch?
It is Constitution permissible to centralize power as enumerated in Article 2. Anything beyond that is not constitutional. For example, the current administration has imposed tariffs. The power to impose tariffs rests with Congress. Congress passed a bill and the president signed it some time ago, allowing the president to impose tariffs, but only under certain emergency situations. So that issue is winding its way through the courts.
Okay. Here's kind of a long one, but it deals with originalism and that interpretation. If the language in the amendments was intentionally vague to allow for future generations to interpret them, what does it mean when certain present Supreme Court justices champion being, quote, originalists, that we can only interpret according to the ideas of the original writers?
Okay, so when law students are in law school, they learn a whole bunch of things that we call the canons of statutory construction. Canon being C-A-N-O-N, rules. So we learn the rules of statutory construction. Those same rules apply to the Constitution and to the amendments. And what it means is, originalism is, you start with the original language of the statute or the amendment or the Constitution. The problem some people see with the current Supreme Court is that it seems that some are going beyond that. So for example, there's a Second Amendment case in which the writing author said, if you have a regulation dealing with firearms, I'm going to look back to the 19th century. If there was a regulation akin to that that was permissible, I'm going to say this is permissible. Now, has there been a change in armaments since the 19th? So when I present on this topic, I have a musket. I bring a musket. It's called a Brown Bess. Is it different to regulate the Brown Bess versus regulating an AR or a multi-capacity magazine? But that's what this particular justice thinks is the rule. So that's what that question is talking about.
What would be the process to limit Supreme Court justices to a certain number of years to serve or have an age limit?
Requires an amendment. Requires an amendment to the United States Constitution. When you look at Congress, they have terms of office. 2 years for House, 6 years for the Senate. There is no term of office for United States Supreme Court justices. There have been people there who have been over 90 years old. I'm 73 years old. There's no way I could possibly do my job on the United States Supreme Court. Why? When you think about the things they have to do, they have to read over 5,000 cert petitions. Joe mentioned cert petitions. Now, they don't read them. What they do is they each have at least 2 clerks. They read them, they synopsize them, and they give them to the justice. But that takes a lot to read. Then you got to prepare for an oral argument. There are 9 justices. 9 justices, right? You're going to have 4 justices agree to let a case in. And then the rest of them will hear the case. They will read 3 briefs from each party. The main brief, the respondent's brief, and then the reply brief. And then you got to read the case law. You don't know this case law off the top of your head, right? You got to read the cases. So they got to read the briefs, they got to read the cases, and then they got to get ready for oral argument. We have one Supreme Court justice now who dominates the argument. And she asks questions, and doesn't quite let the advocate answer. We had a former justice who's deceased, Justice Scalia, who was mentioned, who did the same thing. Having been in the Supreme Court, can you imagine how irritating it is? You've been practicing and practicing and reading, and then all they do is respond to their own questions. Would that frustrate you?
Yes.
Indeed. During our argument, we had the then Associate Justice Rehnquist turn his chair, put his back to us. And I'm looking, I'm saying, this is a Supreme Court justice? He just turned his back to us? What message is he sending? I'm done. He later becomes the Chief Justice. So my point is, it takes an awful lot of intellectual power to be able to sit on the United States Supreme Court. I'm not advocating for an age limit, but I can see a point in time when some of these justices just need to go.
And as you were answering that when you answered this next question, which was what are the criteria the Supreme Court uses to determine cases?
The criteria that the Supreme Court uses to determine cases is set forth in its rules. And what they want is a matter of national concern that has potentially divided the courts. So let's say, for example, you have an opinion from the Ninth Circuit, which is California, versus the Sixth Circuit, which is Ohio, Tennessee, etc. And they come to different conclusions. That's one reason why the Supreme Court would take the case. 2 circuit courts coming to opposite conclusions. Another reason is a matter of national concern. but they can only take a limited number of cases.
60 to 70 a year, I read.
Well, about 100.
100?
You know, in a long term, about 100 cases. That's a lot.
And just for clarification, where in the Constitution does it say Supreme Court justices have lifetime appointments?
3, Article 3.
Article 3. Are there penalties aside from impeachment for defying the Constitution?
Well, let's go back to the 19th century. You had 3 assassinations, right? Late 19th century, early 20th century. You had Lincoln, you had Garfield, and you had McKinley. Now, Lincoln, why was Lincoln assassinated? Why did John Wilkes Booth assassinate him? John Wilkes Booth had attended the second inaugural, and he heard Lincoln talking about slavery and eliminating slavery, and that he was going to be friends to the African Americans, and he gets killed for that. I mean, that's one inappropriate response, is you kill the messenger. But the other method is impeachment. There have been 9 U.S. Supreme Court justices have faced impeachment, and none have been removed. There was a move when we were young, Joe, to get rid of Justice Douglas, William O. Douglas. Rather liberal, rather unusual person, and there was a move, I'm sorry?
And ancient.
He wasn't that old at the time,
Oh.
but they were trying to get rid of him because he was too liberal. So impeachment is the accepted method as opposed to assassination.
You've heard the concept, the king can do no wrong, sovereign immunity, the king can do no wrong. Judges, more often than not, have absolute liability while they're performing their official functions.
Immunity.
Judges, immunity, what did I say?
Liability.
Absolute immunity. Sorry. There are some federal officials, local officials, who are susceptible to being immune. For example, police officers, if they use clearly excessive force, can not only be sued, but can be charged with crimes if a grand jury finds a crime there. Absolute immunity, as you all know, was much in the news in Trump versus the U.S., which came out about a year ago. The Supreme Court took a kind of a layered approach. And back with Nixon, when he was in trouble, they said that a president can't be sued while he's president and be held in civil damages, civil lawsuits, because it would distract from his office. But they didn't want to touch criminal immunity until last year. And they had 3 layers. Core immunity, I don't know if Supreme Court justices, but they had core immunity for, they had absolute immunity for what they call core constitutional issues.
So this is presidential immunity you're talking about.
Yeah. So these are still taking shape. This country's had a tortured history with sovereign immunity, lesser immunity like qualified immunity. There are also ethical standards. You all know there's been some controversy over the Supreme Court and whether or not they had applicable ethical standards that had teeth in them. You know, most judges, federal and local and state, have ethical conduct. Judges can have grievances filed against them. So there are a few other ways. But in the Supreme Court, they're kind of like that old phrase, untouchables. They're almost like the untouchables.
Let me add something about
Sure.
Nixon. The Supreme Court in U.S. versus Nixon sounded the death knell for Richard Nixon by ordering the Watergate tapes. Remember the Watergate tapes? Okay, where talk about a dumb thing. He was recording everything that was said in the Oval Office, but he refused to turn them over. Right? The United States Supreme Court in U.S. versus Nixon said he had to. What did that lead to? Resignation. Pardon. Who pardoned him? Ford. How did that affect Ford's desire to become president? 0, right? So I guess my response to that is, sometimes the Supreme Court has done the right thing. I don't necessarily disagree with the case you're talking about, the recent case, because I think it really followed the way we treat executives in our government. We want them to act without fear. We want them to act without fear, as long as they're acting pursuant to the Constitution. And what the court held in the case Joe is talking about is as long as they're acting pursuant to the Constitution, they're going to be immune. I have no problem with that.
Well, let me ask you the next question then. If the president acts unlawfully and the courts or a judge finds it truly unlawful, read unconstitutional, yet the president continues to ignore this, what can be done?
Andrew Jackson. Anybody remember that name? Okay, so Andrew Jackson is a very unusual guy. Got into a lot of fights over his wife, duels. Becomes the president of the United States. And the United States Supreme Court is considering a case where it's dealing with the Cherokee Nation. And it holds that Georgia has no authority over the Cherokee Nation. And we then follow with what's called the Trail of Tears. Jackson famously said, okay, the United States Supreme Court has issued its ruling, let them now enforce it. Right? So what does that say? I'm not going to follow your rules. The interesting thing is, the body that enforces the rules, if force is needed, is the U.S. Marshal Service. Guess which department the U.S. Marshal Service operates under? Department of Justice. So if you're a federal court judge, and you got a U.S. Marshal, right? That marshal is working for the DOJ. What does that prompts certain questions as well. Is the DOJ going to authorize that person to act? That's an open question. If we hit that point where a president decides not to abide by the United States Supreme Court, we have then hit an incredible constitutional crisis. Because if you don't abide by the United States Supreme Court, which is the supreme law of the land, then you're ignoring the very basis of the Constitution. If we hit that point, we're in trouble.
Okay, the next question may have come from a lawyer here. Two questions. Contrast the balance of power with unitary executive theory. And the second part is, what can limit abuse of shadow docket?
You don't want to limit the abuse of shadow docket. Shadow docket has been around for decades. And what that means is the court has to expend a lot of resources in deciding what we call a merit case. A merit case would be, you're representing one side, you're representing the other, you file your briefs, you file your briefs, we have oral argument, we issue an opinion. But they get so many cases that they can't possibly do that. So more often than not, when it's a very clear ruling, they will issue an order that says something can or cannot be done. More often than not, it's dealing with an injunction. An injunction allows the court to order somebody or some entity to do or not do something. So we're seeing a lot of that, but that's not that unusual.
But there's not very, they don't provide explanation.
Well,
And
I
that's
was going to say, is the media is making a big deal out of that. It's not that big a deal. It's been happening for decades. Now, it may be happening a little bit more now, but that's a function of many things. You have a very deeply divided court. You've got several very liberal justices. You have several very conservative justices. You have a code of conduct. Guess who enforces the code of conduct for the U.S. Supreme Court? The U.S. Supreme Court.
Okay, let me ask you the first question then, because apparently the answer is nothing that can be done to it about the shadow docket. Groan, right? Okay, and contrast the balance of power with unitary executive theory.
I don't know what unitary executive theory is. I don't know either.
It's the theory that more power should be held by the executive branch.
I reject it.
And so it flies in the face of the idea of
Exactly,
separation.
I agree. I mean, so the whole idea of the Constitution is born out of the framers' experiences, both historically and their education, and also their recent experience with George III. And so they did not want to have an absolute rule, and that's why they had checks and balances.
But checks and balances only work
If
the other branches actually do something.
That's correct.
There are some among us who think Congress is failing in their oversight role. There are others, maybe that don't think so. The consciousness, and again we're back to the vote, the consciousness of each branch forms as people are added to it. And in time, that consciousness usually shifts one way or another in the executive branch, in the legislative branch, and the judicial branch, sorry. So that's why I think your vote is so crucial, and we're so glad that you're here, so you can make informed decisions.
But you also have to think about Congress. Congress doesn't have term limits. They have 2-year terms in the House, and you can serve 20. You have 6-year terms in the Senate, you can serve 10. You can serve as many as you're alive. But in the presidency, you're limited. You're limited, right? So the key amendments there will be the 12th, the 22nd, and the 25th. If you want to run for office, for example, as the vice president, you have to be eligible to hold the office of the presidency. In the event the president dies, the 12th Amendment says you got to be eligible. Okay. The 22nd Amendment, talks about what you can and cannot do. The 25th Amendment talks about getting rid of the president if the president is incapable of pursuing the functions of the job.
So we have a question here, comment on Amendment 22, just so when you're talking about the limit of 2 terms as president, but we might have heard conversation that somebody wants to run for a 3rd term.
Well, you've also heard a couple of Supreme Court justices I guess you'd call it off the record, but they're making presentations. And their point was, there's been no resolution of whether you can have more than 2 elected terms, because it's never happened. We've never had to think about it. Some of them are saying, well, that's an open question. Indeed it is. There's no U.S. Supreme Court case. But the language is pretty clear. No person can be elected to the position more than twice. The current occupant of the White House has already been elected twice.
Okay. What was the original purpose of the Electoral College?
There was no original purpose. They didn't have it. So when they have the Electoral College by amending the Constitution, what they're trying to do is, instead of having a regional person, a person who wins in a region, let's say there's a governor in California, a guy named Newsom, we'll make up a name. Assume he wins California, he wins all the western states. The idea of Electoral College is you got to win a bunch of other states too. So you can't win all the popular vote in a region and become president. You have to get other votes. Now the Electoral College in a couple of votes ago was really in question. There were some lawyers who were advising the candidate that you could have another ballot, you could have another set of ballots, as opposed to the one that was created by the people, elected by the people. Those lawyers, for example, a guy named Eastman, is now facing disciplinary actions because of his egregious conduct. Another lawyer, Sidney Powell, is also facing disciplinary problems because she's a female, the cracker. Yeah, you're shaking your head now. No? Sidney Powell's a female.
Yeah, she's dead.
She died? No. I don't think she died. No. And the other one is a guy named Rudy Giuliani. Rudy Giuliani's been disbarred. Okay, Rudy Giuliani, the interesting story about Rudy is, as you know, he was the mayor of New York City during 9/11. He was also a U.S. attorney, a hell of a U.S. attorney. But after he lost the nomination for president in 2008, he began drinking. He began drinking excessively and became an alcoholic. Guess where he went to dry out? Mar-a-Lago. He went to Mar-a-Lago to dry out, and he became embedded in the president's circle. And he sacrificed his legal career.
Okay. 2 last questions here. Are anchor babies...
Or what?
Anchor babies, the idea of children of non-citizens who are born in the U.S.
You're talking about birthright.
Birthright, yes. Are they citizens at birth?
Yes.
That was an easy
Okay,
answer.
so the reason for that was the Dred Scott decision, right? In the Dred Scott decision, the United States Supreme Court held that Dred Scott could not sue in federal court because he was not born in the United States. Okay, he was a slave. He was trying to contest his slavery. So the United States Supreme Court holds that he's not a citizen and he can't come to court. The 14th Amendment, one of your, I guess, an older legislator, John Bingham, was behind the 13th, 14th, 15th Amendments. And John Bingham created the 14th Amendment to overrule Dred Scott. So anybody born in the United States is automatically a citizen. We're seeing that controversy play out right now, where people from, for example, El Salvador, the husband or the wife is being deported. Hell, the kids are born in the United States. They're American citizens. Unless you're willing to ignore the 14th Amendment, they're American citizens.
And the United States Supreme Court in 1898 affirmed that principle in the United States versus Wang Kim Ark, a Chinese person who was a citizen and was born here, Chinese extraction.
But the exception, they drew an exception in that case.
Right.
And what the court said there is, well, if you're here, for example, as a member of a family of a diplomat, then you're not subject to the jurisdiction of the United States, and therefore if you're born here, you're not an American citizen. But other than that, everybody's an American citizen.
And the interesting thing about the case that just came out 3 months ago, and you can write this down and look at it, it's called Trump versus CASA. Trump versus CASA, Washington, and Trump. Anyway, a number of district courts and the courts of appeals said your executive order is not going to hold constitutional water. But what it turned into by those 3 district courts and 3 courts of appeals was it became more a matter of procedure. Can a district court in one state universally stop all the other state district courts? And the court went with that issue as opposed to trying to decide once and for all if is means is, if the language is what it is. So that's something you've got to tune into. The courts seem to fashion this thing saying one district court can't fashion a universal stay for all the rest, but they have some circumstances, almost like a class action, as I read.
Well, it can. There's an exception to that.
Yeah.
If you're drafting a complaint, right, and you want to contest something that has national effect, what you do is create a class action and have a class representative from every state. And that's how you overcome that decision, what you're talking about. So you have a class representative from every state. So when you issue the injunction, it applies across the country. That's what I would do.
Well, that's interesting. It ties in with this last question, and it's written in a very bold handwriting. It says, what would it take to create a stop button when the president creates executive orders which are blatantly against the Constitution? This person is looking for an executive order that would not be able to go into effect immediately.
There's no such thing. It's going to have to take litigation. The beautiful thing about executive orders is that the next president can also issue an executive order. And that executive order can do away with the previous one.
And to follow up on Dean, executive orders exist at the federal, state, and local level. Presidents can issue them, every administration. Governors can issue them, every administration. Mayors of cities can issue them. But the important thing is, in order for it to hold water, constitutional water, it has to address something that's kind of silent, that really hasn't been addressed head on and square on. Because if Congress has spoken clearly, you really shouldn't be issuing an executive order that contravenes that. If there's language in the Constitution that seems pretty clear, you really shouldn't be issuing an executive order to contravene that. Or, as Dean pointed out, and Annie's shaking her head, it's going all the way to the Supreme Court, and there we are. There we are.
I think what we see with this president is an unprecedented number of executive orders. And those have been passed out very quickly, but the trial procedures, the court procedures are glacially slow. And I think that...
But you want slowness. When you're dealing with important constitutional issues, what you want is very studied, very serious academic review of the positions of the parties. And so I have no problem with the fact it takes a long time.
Wow.
But
Okay.
it creates a problem in that interim.
Well, as long as you have the right class action, you can enjoy it.
Yeah. Okay, so sign up 49 of your best friends in other states.
No. If you're concerned about this, you should donate money to organizations that litigate these issues.
Okay. So would you please join me in thanking this fine panel? provided these free of charge for you. If
Joe,
you-
Joe and Dean.
What's that?
Joe and Dean.
Joe and Dean.
Dean ordered them.
Okay.
Thank you.
Thank you.
If you plan to keep this and use it and put it in your hip pocket, then take it home with you. If
Otherwise,
you-
leave it.
Yeah, otherwise leave it. Also, Amy brought the other ones that have a different color, so thank you to all of you. I'd like to direct your attention to the program. We have another program coming up on October 21st that deals with immigration, facts and myths. Joe is helping us organize this, and it will involve at least 3 attorneys who are immigration and naturalization lawyers. So if you're concerned about immigration or know people who are, be sure to come to that event. And just on a personal note, as a parent and a grandparent, or as any thoughtful person, I'm not pleased with the world that our young people are inheriting. We have climate change, we have social justice issues, we have artificial intelligence, and a lot more significant challenges. The key to helping future generations find solutions to tough problems, I believe, is to leave them a robust democracy grounded in fair districts and voting rights. Our Constitution cannot protect itself. Each of us needs to speak up individually and collectively. The League, on a national, state, and local basis, welcomes your involvement to help defend democracy and empower voters. A couple of us, Okay, before we wrap up, I want to remind you that to get out of the park, you must turn right and continue around the circle. Do not go back the same way you came in, because that's one way, and that's the inside way. We could have some bumps. So continue to turn right and go out, and you will find your way out eventually. I would like to ask all of our league members who helped make this event possible to stand up. I would say there were about 20 or 25, some of them very shy. And I really want to thank all of you for taking the time out of your lives to come here for this very important event tonight. And I would like to applaud you for being here. So, thank you. Well, anything else? Anybody? Surveys. Oh, surveys, thank you. Yes, remember to complete the survey that's on your seat and put it on the table as you exit, or hand it to a league member. Anything else? Thank you all. Enjoy the rest of your evening.